Today we're talking about whether a person riding in a car can sue the driver of that car in Alabama if the driver does something negligent, something wrong that causes the wreck. Well, in most states, yes, you would just have to prove that the driver was negligent, that they ran a red light or rear-ended somebody else. But in Alabama, we have what's called the Alabama Guest Statute. It's code section 32-1-2. And it was passed almost 100 years ago, and basically says this: a passenger cannot sue the driver of a vehicle unless two exceptions apply, one of which has to apply, and if they don't, you can't win your case. The first exception is that if the driver was driving wantonly or recklessly. So what does that mean? That means more than mere negligence. And negligence is just like when you make a mistake, like you misjudge the stopping distance and rear end somebody. That's a good example of negligence. Wantonness or recklessness is when you're consciously disregarding the safety of others. Common examples of that include drinking and driving or street racing. So if you're a passenger and you can prove the driver was doing something real reckless like that, then you can still win a claim against the driver. The second exception to the Alabama Guest Statute is if you were providing a material benefit to the driver, then you can still win a claim against the driver. A material benefit, that can be you're splitting the cost of gas on a road trip. That's one of the common ones we see. But it doesn't necessarily have to be money that's benefiting the driver. You don't have to pay for the ride. Material benefit can be other things, and I'll give you an example. We had a case involving two elderly women who were going to Walmart together to buy groceries, and they went together because they helped each other load groceries into the car. The driver had some mobility issues. It was tough for her to get around, to shop on her own. So our client was riding as a passenger to go help her with her groceries. And as our client was getting out of the car, this elderly woman accidentally let the gear shift go forward and ran over her leg. She had bad injuries. Well, we were able to successfully argue that our client was providing a material benefit by going to Walmart with this elderly lady to help her with shopping and loading her groceries in her trunk. So that's the second exception. If you can't prove either exception, then you're not going to be able to successfully win your claim against the driver. So if you've been a passenger and you want to bring a claim against the driver of the car that you were in, start thinking about whether one of those two exceptions applies.